Hey, good afternoon. Wanted to touch base about a few things that came up in the practice today, and they've come up more and more in the last couple of weeks, and that is the exercise of the right to jury trial and how you can exercise that right or not in a family law case, because you have a limited right to a jury trial in a family law case, and I'll get into that in a minute. But also the reason why it's important to think about and consider exercising your right to a jury trial in a family case, or in any case. Our founding fathers, and I've talked on and touched on this before, our founding fathers thought that the right to jury trial was so important that it's mentioned multiple times in the founding documents of these United States of America, the Constitution, the Bill of Rights. And the thing about that is, I think it's a total of 3 times, but I may be wrong. While the Texas legislature has prescribed how those rights are exercised in a family law case, you do have those rights for certain things, and you need to be cognizant of them, and you need to, in certain cases, in the right cases, you need to not be afraid to exercise. The reason why the right to the jury trial is so critical is because that was not a guaranteed right under the laws of the British dynasty. So what are those situations? Well, there are certain things that a jury gets to resolve in a family law case. The first of which is conservatorship, and that's how we define parental rights. And there's a certain definition under the Texas Family Code for parents and what their rights are. Joint managing conservators is what most parents are granted, and that's, equal rights, equal decision making. A jury also gets to decide some property related issues, whether or not a certain property has a characteristic as separate property. Remember, the presumption in Texas is that everything acquired or earned during a marriage is presumptively community property. It means it's 50-50 owned by either spouse. And anything that is community or separate, the jury gets to decide the character of that property. Did you properly prove that it was separate property coming from either before the marriage or an inheritance or other separate property transfer? Whether a spouse is entitled to a reimbursement claim for contributions to separate property, contributions to some asset that is not community property, and then whether or not premarital agreements or postmarital agreements regarding Another thing a jury gets to decide is whether parties are in a common law marriage. What we call common law marriage means an informal marriage. Maybe there's an exchange of rings or holding out. You call each other Mr. and Mrs. Took a last name on a checking account and on a deed, but perhaps not formally with the county, didn't formally change name. But whether or not you held out enough to be informally married, whether or not a party is at fault in a divorce, which would entitle a party to make an argument for an inequitable division of property to the court, and then whether or not annulment is appropriate. And of course, the issue of attorney's fees. Are they available? Should they be awarded? Where you don't have the absolute right to a jury trial in a family law case are issues for the court. These are questions of law, and that is the visitation schedule, what we call in the family code possession and access, how child support will be determined, whether each parent will have and which decision-making powers they'll have. For example, things like invasive surgery, consent to join armed forces, things about that, things governing the decisions of your children, which parent gets those decision-making powers, how community property is divided once it's been determined to be, once its character has been determined, is it community property, is it separate property, and then how that community property will be divided, confirmation of separate property, spousal maintenance. If you've been married for a certain period of time in Texas, you are entitled to what we don't have alimony, but we have spousal maintenance. And then issues like adoption, paternity, enforcement of the language of prior orders. These are all questions for the court. You don't have an absolute right to a jury trial on them. These are questions of law for the judge. So again, I'll stress that not every case is ripe for a jury trial or should be tried to a jury. Our founding fathers felt that the right to jury trial was so important that they preserved it for us and for our children and grandchildren, and that they incorporated it into the Constitution the Bill of Rights, the preamble. It's part of our culture, the right to a trial by jury. And sometimes you need to be able to ask the jury for the relief you requested, and you need to not be afraid to ask the jury for the relief you requested. I'm not saying you won't get a fair shake in front of the trial court. The trial court is where. Hope you have a wonderful weekend, and don't be afraid to exercise your right to jury trial. You need to be conservative and judicious in the use of this right, but don't be afraid to exercise that right. That's what the Founding Fathers intended us to do.